Okay, good morning, everyone, or good evening, depending on where you are. Thanks for joining us this morning. So I'm just going to do a quick intro. This will be your time to ask questions regarding work visa options, immigration policies. We have Mark Rhoads here. I'll let you introduce yourself, and then you can take it from there. I will say, before we get started, if you have questions, please pop them in the chat box, and then once the presentation is over, we'll go over them. We also have Jeremy Spoor here from ISSS. So we've got a lot of great minds here to answer all of the questions that you might have. So without further ado, I will let you take it away, Mark.
Thanks very much. My name's Mark Rhoads. I'm an immigration attorney. What that means is that what I do for a living is that I work with companies and I work with universities all over the United States, and I help them process work visas and permanent resident green cards for international employees. I work a lot with career services offices and international student offices at universities all over the United States, trying to help international students and employers understand the process that international students will follow in order to stay and work in the United States after graduation, if that's your desire. I can tell you that there's been a lot of new policies, new proposals, a lot of noise, a lot of smoke coming out of Washington, D.C. with regard to the immigration options that are available for international students. As is typical, I've been practicing immigration law for 28 years or so. I've seen many proposals, proposed policies come and go. Many of these policies that have been proposed by the Trump administration, although they caused a lot of turmoil and anxiety, most of them have either been stricken down by courts or withdrawn by the administration. So what I'm going to try to do here in the course of the next hour is I'm going to explain to you the law currently and the options that are available to you all as international students right now to stay and work in the United States after graduation. That will give you at least a baseline. If there are changes that come down the road, you'll at least have an understanding about what the rules are now and how those changes in the future might affect you. But my own guess is, as with so many proposals over the years, most of these will come to nothing. So my own working assumption is that the process that international students have followed for many years will continue to be the process that you will follow if you want to stay and work in the United States after graduation. I do a lot of these Zoom calls, and I think I have some kind of anti-technology force field because inevitably my screen freezes or my audio crashes. If something happens like that, or if I do not get around to answering your question, my contact information is up here on the screen, as well as the contact information for one of my law partners, Helen Conrad. We are available to answer questions. If you have questions about the process for staying and working in the United States after graduation, feel free to call me or send me an email. If you are talking to an employer, and if the employer has issues or questions about this process, tell the employer to give me a call, send me an email, and I'm happy to answer their questions. And that's important because I answer questions for free. We answer many hundreds of questions from international students and from employers every single year. So it's a great free resource that's available to you. So I encourage you to take advantage of it. All right, so what is the typical path that an international student will follow when they graduate from a U.S. university and they want to stay and work in the United States? Well, here's the path. I've been, as I said, been doing this for about 28 years. I've spoken to thousands of international students over the years and helped them in this process. The process that I have up here on the screen right now is the process that 95% or more of every international student will follow to stay and work in the United States. And that process is this. If you're an F1 student, you will get something after graduation called Optional Practical Training, OPT. Every international student is eligible for 12 months of OPT. If you're in a STEM degree program, you'll get an additional 24 months for a total of 36 months of optional practical training. Optional practical training is the best way for an international student to get their foot in the door with an employer, because the employer doesn't have to do anything. The employer doesn't have to file paperwork with the government. They don't have to pay any fees. All they have to do is decide that they want to hire you. And as long as you have your optional practical training work card, you can go to work for that employer. You cannot go to work for the employer until you have the card. Jeremy is available to answer questions about optional practical training. The ISSS office at Penn is incredibly experienced, one of the best that I've dealt with at any university anywhere in the country. And they are very, very helpful. And I encourage you to reach out to them with regard to questions regarding optional practical training, because again, it is the single best way for you to stay and work in the United States right after graduation. While you are working for this employer or an employer using your optional practical training for that 12 months or 36 months, you're going to want to talk to the employer about pursuing an H-1B. H-1B is the most common work visa in the United States. It will allow 6 years of work eligibility. That can actually be extended beyond 6 years in some circumstances that are beyond the scope of our discussion today. So assume that H-1B will allow you 6 years of work eligibility. So you start with your optional practical training, then you will move on to the H-1B. And if you want to pursue a permanent resident green card during your 6 years of H-1B, then you can pursue a permanent resident green card. Let me talk very quickly about permanent residence, because I get lots of international students who ask me questions about getting a permanent resident green card. First of all, what is a green card? A green card, it looks like a driver's license, and it actually is sort of a minty green color. Once you get a permanent resident green card, it means that you can live in the United States for the rest of your life. You can work for any employer without restriction. You can travel freely in and out of the United States just using your passport and your permanent resident green card. You never have to go and get a visa ever again. So getting a permanent resident green card has great benefits in terms of employment, in terms of travel, in terms of security and living in the United States. But the problem with a permanent resident green card is that there are only very limited ways to get a green card, and they take a very long time. There are essentially 2 ways to get a green card to stay and live in the United States. One way is based on certain family relationships. That is, if you have a family member who is in the United States and that family member is either a US citizen or a permanent resident, that family member may be able to sponsor you for a green card. Not all family members qualify. The family members that could sponsor for a green card are what they call immediate relatives, and those are parents, spouses, children, and in some cases, brothers and sisters. So if you have a parent or a spouse or a child or a brother or sister in the United States, and that person is either a permanent resident or a US citizen, they may be able to sponsor you for a green card. I'm not going to talk a bunch about family-based permanent residence. If you have questions about a family member and whether that family member could sponsor you, such as a US citizen spouse, feel free to send me an email, give me a call, and I'm happy to discuss that issue. Putting aside family-based immigration, the other way to get a green card is based on employment. That is, if you have an employer who is willing to sponsor you for a permanent resident green card, there is a lengthy process the employer has to go through to sponsor for permanent residence. But the most important thing about employment-based permanent residence is that the first thing you have to have is an employer. You can't pursue an employment-based permanent resident green card on your own, with the exception of certain individuals with extraordinary or outstanding abilities. For most international students graduating from a US university, they first have to get an employer, and the employer has to go through a process called PERM labor certification. I've never known an employer in 28 years of being an immigration attorney who is willing to go through the PERM process before you become an employee of that employer. And the way to become an employee is not through permanent residence. The way to become an employee is based on temporary work visa options, such as optional practical training, and then the H-1B. And because those options are so important, that is obviously going to be the focus of what we're going to talk about today. If you have questions about employment-based permanent residence, feel free to send me an email, give me a call. I'm happy to talk to you about them. There's also a document that I will share with Kevin and with Jeremy. It's called My Easy Guide to Hiring Foreign Graduates. It's a 1-page piece of paper that goes through these issues from the perspective of an employer. In other words, it talks about F1 optional practical training. It talks about the H-1B, and it's written in terms that employers understand, such as what is the cost of this process? What is the timing of getting the optional practical training? What's the timing of getting the H-1B? What are my obligations as an employer to this international student when I hire this person as either an optional practical training employee or as an H-1B employee? So I'll send that easy guide to hiring foreign graduates, a very helpful piece of paper, and I encourage you to hang on to that. If you have employers that have questions about the process, feel free to give the employer a copy of the easy guide and encourage the employer to give me a call. I'm happy to answer their questions. So let's look at step number one for staying and working in the United States, and that is optional practical training. I don't want to spend a bunch of time on this, but I do want to mention a couple of things that I see in my law practice every year that are problems for international students. And these are ways that you can hopefully avoid these problems. So step number one for staying is to get your optional practical training work card. That card looks like a little driver's license. It will have an effective date that you can request anytime within 60 days after graduation. The card is called your Employment Authorization Document, your EAD. You'll hear people on the internet all the time talking about their EADs. That's just their work card. Importantly, there is a window to apply for this card. You can apply, you don't have to have a job. You don't even have to have a job offer in order to apply for this card. You can apply for the card up to 90 days before completion of your program, which for most people is graduation, or up to 60 days after. So I always recommend go back to your dorm or to your apartment, find your graduation date, circle it on a calendar, and count back 90 days. That's the first day that you can apply. There is no reason to delay. You must have that card in your hand in order to go to work for an employer. You cannot work without the card. If you work before you get the work card, you are deportable from the United States for unauthorized employment. If an employer puts you to work before you have that card, the employer can be fined by the federal government. No employer wants to take that risk. So the first step is to get your optional practical training work card. You can apply up to 90 days before graduation. You should apply early because right now it is taking the Immigration Service approximately 120 days to process that work card. So if you want that card to be in your hand and effective as soon as possible after your graduation so that you're eligible to go to work, apply for the card as early as you can. You can apply up to 90 days before graduation, and I encourage you to work with the ISSS to make sure that your application is properly submitted. Once you get your optional practical training work card and you go to work for an employer, you're going to want to start thinking about longer term ways to stay and work because the initial optional practical training work authorization period is 1 year, 12 months. During that 12 months, if you're in a STEM degree program, science, technology, engineering, or math, you can qualify for an additional 24 months of optional practical training. But not all STEM grads will qualify for that additional 24 months. In order to get that additional 24 months of OPT, you must be working for an employer enrolled in the E-Verify program. E-Verify is a program that allows an employer to electronically submit documentation about their workforce to the federal government to prove that all of the employees employed by that employer are legally authorized to work in the United States. It is a voluntary program. Not every employer is enrolled in the E-Verify program. If you want to get the additional 24-month STEM extension of your optional practical training, you must be employed by an employer enrolled in E-Verify. If the employer is not enrolled, you do not get the additional 24 months. And I get many students who say, well, how do I know if the employer is enrolled in E-Verify? And the answer to that is ask them. Every employer enrolled in the E-Verify program knows whether they are enrolled. If your employer is not enrolled, they can enroll at any time and you can qualify for that additional 24-month STEM optional practical training extension. In other words, the employer does not need to be enrolled at the time they employ you. They can enroll in the E-Verify program at any time. So that's a very important limitation on the STEM extension of optional practical training. So you get your initial 12 months of OPT. If you're in a STEM degree program, science, technology, engineering, or math, you get the additional 24 months if you're working for an employer enrolled in E-Verify. But whether you're working using the 12 months of OPT or the additional 24 for a total of 36, you know that at some point that clock is going to run out. And in order for you to stay and work longer term in the United States, you could pursue a permanent resident green card while you're using your OPT. In most circumstances, you will not have enough time to get a permanent resident green card while you're using your optional practical training. So you're going to want to start thinking about temporary work visas that will allow you to stay and work for a longer period of time in the United States. And as I said, the most common work visa to allow you to stay and work is the H-1B. For H-1B, there are essentially 3 requirements to qualify for H-1B. Thinking back to optional practical training, to qualify for that, all you had to do is graduate from a U.S. university. You can apply with it in your last semester, 90 days before graduation. You didn't even have to have a job offer. H-1B is very different. There are 3 requirements for the H-1B. Requirement number 1, you have to have an employer. For OPT, you didn't have to have an employer. You could apply for your OPT work card even without an employer, not H-1B. H-1B, you must have an employer. Only an employer can file an H-1B petition. You cannot file an H-1B on your own. It is an employer-sponsored visa. Second requirement, you must have a degree. You have to have at least a bachelor's degree. It can be a bachelor's degree from the United States, or it can be a bachelor's degree from outside the United States, as long as it is the equivalent of a U.S. bachelor's degree. If you are in a graduate program right now at University of Pennsylvania, you already satisfy that requirement, because in order to get into a graduate program, you had to have an undergraduate degree. So as the second requirement, you must have a degree. Requirement number 1, you must have an employer. Requirement number 2, you must have a degree. Requirement number 3 is that the degree that you have must relate closely to the job that you are either doing or the job that you are offered. In other words, there has to be a very close correlation between the duties of this job and the coursework that you took in your degree program. This third requirement is the single biggest reason that H-1Bs are denied under this administration. Denials in this administration have essentially quadrupled for H-1Bs. And the single biggest reason for denial is that the Immigration Service says, I don't think that your degree has a close enough connection to the job that you're being offered. So the exercise that we do in our office, denials of H-1Bs are up around 25, 28% of all H-1Bs that are filed. Coming out of our office, we have less than 1% denial rate. One of the reasons for that is that we are very rigorous about requiring employers and students to go through the following exercise. And that is, when you're offered a job, or if you're working using OPT and you go to your employer and you talk to them about filing an H-1B, the employer says, sure, I'll do the H-1B. Let's call this Rhoads guy, talk to him. What do we need for the H-1B? First thing, you have an employer. Second thing, you have to have a degree. Now let's see how closely the degree relates to the job. I usually tell the employer, give me a bullet point listing of the top 10 most important functions of this job. And then I say to the student, you go through your transcript and you tell me the coursework that you took in your degree program that trained you, that gave you the knowledge that allowed you to perform that function. And if you can make a very close correlation between the coursework that you took and the duties of the position, then you will have a very strong H-1B. If you cannot make a close correlation, if you're really struggling to make a correlation between the coursework that you took and the duties of this job, then you're going to have a weak H-1B, and I would encourage you to look probably for another job that is more closely aligned to your degree. Because again, this is the single biggest reason why H-1Bs are denied. The Immigration Service says that the degree does not relate closely enough to the duties of the position. But assuming that you have an employer, you have your degree, you show that there is a close correlation between the duties and the degree and your course curriculum, The employer files an H-1B application with the Immigration Service. Right now, it's taking the Immigration Service roughly 5 months or so to process an H-1B. You can ask for what's called premium processing, which is 15-day processing for an additional filing fee of $2,500. But assuming your case is approved, what does that get you? Well, it initially gets you 3 years of H-1B work authorization. You can then file for an additional 3 years of H-1B work authorization for a total of 6 years. When you had your optional practical training, that OPT work card allows you to work for any employer anywhere in the United States doing any job, as long as the job is related to your degree. No wage requirement, no requirement. You could transfer from one employer to another. You just need to notify the ISSS. H-1B is very different. When you get an H-1B, you can only work for the employer who sponsored you for the H-1B. You can only work in the job described in that petition, and you can only work in the location that was listed in your H-1B petition. If any of those things change, if you move to a new employer, or if you start doing a job that's different than what was described in the H-1B petition, or if you move to a new location, you may need to file an amended H-1B petition. And I recommend to employers all the time, before you make any changes with your H-1B employee, whether it's moving them to a new location or whether it's changing their job duties, contact me first so that we can determine whether or not an amended H-1B is necessary. But when it comes to working just for the employer who sponsored you for the H-1B, does that mean that you're stuck with that same employer for all 6 years? Do you have any ability to move to a new employer? And the answer is yes, you can move to a new employer, but if you move to a new employer, the new company will need to file a new H-1B on your behalf. So anytime you change jobs, you have to file a new H-1B petition. Why is that? Because it may be that the first job, there is a close correlation between the duties of the job and your degree, but it may be that the new job you're going to, there is no close correlation. So every time you change jobs, the Immigration Service wants to evaluate whether the duties of the new job are closely related to your degree program. So every time you change jobs, you have to file a new H-1B petition. One benefit of filing a new H-1B petition for a new employer is that you can change jobs immediately upon filing the H-1B. You don't need to wait for an approval. And when you change jobs, you are no longer subject to the H-1B quota. You're no longer subject to the H-1B lottery. You can file the H-1B with a new employer anytime and start to work for that employer right away. And I'm going to get back to the H-1B lottery in just a second. But here's a big issue that I find in my practice with regard to the H-1B, and that is the cost of the whole process. It's much more of an issue for students than it is for employers, because many students think that, gee, the cost is so high, it's prohibitive. You read all kinds of nonsense on the internet that costs $10,000 to do an H-1B. Here's the fact of the matter. Most companies are not intimidated by the cost of the H-1B. There are essentially two categories of cost for the H-1B. Category number one is an attorney fee, my fee. Most companies do not have in-house expertise to prepare H-1B petitions, and so they hire an outside lawyer like me or other immigration attorneys. At my office, we charge $2,600, $2,600 to prepare and file an H-1B application. So different different attorneys will charge different amounts, but in our office, it's $2,600 bucks. Then you include on that the government, the CIS, Immigration Service filing fee. The filing fee has a number of different components. There's a base fee, a fraud prevention fee, a training fee of different amounts. Here's the short answer with regard to the filing fees. If you go to work for a company that has 25 or fewer employees, the government filing fee is $1,710. If you go to work for an employer with more than 25 employees, then the filing fee is $2,460. So let's assume you go to work for an employer with more than 25 employees. My fee, $2,600 bucks. The government filing fee, $2,460. So that's $5,060 to process an H-1B application. Now, when I tell that to students, they always go, no employer is going to spend that kind of money to hire me. But I can promise they do. Every single year, Hundreds of thousands of H-1B applications are filed by employers. They are not intimidated by this cost. And when I talk to employers about this, because I often get calls from employers who have talked to an international student who heard this presentation, and they'll call me up and they'll say, okay, I got this great international student. I want to offer him a job. And I say, okay, fine, OPT, then you do the H-1B. And the first question they ask is, well, what's it going to cost me? And I tell them, my fee, $2,600, government filing fee, $2,460. And I go, what? I'm not going to pay that. And I always say, fine, okay, let's just explain that this is nothing more than a usual recruiting cost. You have an excellent international student that you want to hire, think is going to be beneficial to your company, and you're going to let that student go. I promise you, you're going to spend at least $5,000 continuing to interview on campus, continuing to run ads, continuing to send people out, recruiters who are looking to fill this position. All of that costs money. Those are called opportunity costs. And when I explain that to employers and I tell them it's just a recruiting expense, they always go, oh, okay, I never thought of it that way. And that's what I encourage you to tell the employer. Don't be intimidated by these fees. Employers are definitely not intimidated by these fees. And by the way, these are employer expenses. In other words, who has to pay these costs? The employer has to pay. By law, they cannot pass that cost on to you. They cannot have you pay these costs. It's an employer obligation. Attorney fee and the government filing fee must be paid by the employer. But as I said, employers are not intimidated by that. So if they're not intimidated by the cost, what's the intimidation factor with regard to the H-1B? Well, here's the biggest single problem with the H-1B program, and that is this quota. There is a quota on the number of new H-1Bs that the government can issue every single year. The quota year runs every year from October 1 to September 30. So the quota year that we are in right now started October 1 of 2020, and it will run until September 30 of 2021. So we're a little over 2 months into the quota year. Every year on October 1, the government makes 85,000 new H-1Bs available. And when I say new H-1Bs, what I mean is for individuals who have never had an H-1B ever before. Once you get your first H-1B, you are no longer subject to this quota. You can extend for your additional 3 years, no problem. You can move from one employer to another, no problem. You can file that application anytime. But the very first time you get your H-1B, you are subject to this quota. The quota of 85,000 is divided into two different buckets. There is a bucket of 20,000 that is available just to individuals who have a United States advanced degree. That is, any degree above a bachelor's degree from a U.S. college or university. So the advanced degree quota of 20,000, then you have the 65,000 quota that is for everybody else. Anybody who has any kind of a bachelor's degree or higher from a university anywhere in the world. So let's say you have a PhD from China. Well, that's not a US advanced degree, so you are in the 65,000 quota. If you have a master's degree from Penn, you're in the 20,000 quota because that's a US advanced degree. Let's say you have a master's degree from Canada, you're in the 65,000 quota. You have a bachelor's degree from the United States, not an advanced degree, so you're in the 65,000 quota. Only individuals with a US advanced degree are in this 20,000 advanced degree quota. And I get students who are in advanced degree programs all the time who are crazy to make sure that they get into that advanced degree quota. My answer is, it doesn't matter which quota you get into. As long as you get a quota number, you don't care whether it's an advanced degree H-1B or one of the regular H-1Bs, they are the same thing. So it doesn't matter which quota, there is a small advantage if you do have a US advanced degree, because you will get 2 opportunities in the lottery. And I'm going to talk about that in just a second. So now let's look at the quota year. Quota year began October 1 of 2020. We're a little over 2 months into it. On October 1, 85,000 H-1Bs became available. A little over 2 months. Anybody have any idea how many of those 85,000 are still available? And the answer is none. There are no H-1Bs currently available. And in fact, every single one of those 85,000 H's were taken on October 1, the very first day the quota was released, all H-1Bs were taken. Well, how did that happen? Let's see. The reason that happens is because you are permitted to apply, pre-apply for an H-1B even before the quota is released. You can actually apply in advance to try to get one of those H-1B quota numbers. Now, in all previous years that I've been practicing immigration law, to pre-file for the H-1B, you had to file a whole petition on April 1, exactly 6 months before the quota was released. You had to get a full H-1B petition together. You had to show the close correlation between the degree that you have and the duties of the job. You had to pay the attorney $2,600. You had to pay the full government filing fee. So it was an expensive process just to get yourself into the lottery. This year, the government has changed this process, and this is probably going to be the process going forward for the indefinite future. And that is, there is now a pre-registration period for the H-1B quota, and that pre-registration period starts March 1. You file it, or the employer files a pre-registration anytime between March 1 and March 20. So there's a 20-day pre-registration period for the H-1B quota. So starting March 1, employers will submit not a full H-1B petition as they were required to in the past, but a very skeletal petition that basically identifies the employer. It identifies the individual that they're going to file the H-1B on behalf of, that would be you, and gives very basic information, essentially passport information. There's no requirement to show what the job is, no requirement to show the correlation between the degree and the duties of the job. It's a very basic skeletal petition. In our office, we charge $500 to prepare this H-1B pre-registration. The government filing fee is $10. So the barrier to entry to file for an H-1B pre-registration is very low, $510. Because of that, many employers filed H-1B pre-registrations this year. Nearly 200,000 employers filed H-1B pre-registrations for the 85,000 quota. What does that mean? That means that when the government gets all of these H-1B pre-registrations, they then do a random lottery. And that is, they take all the H-1Bs that were filed. And when you file the pre-registration, you say whether or not it is an advanced degree or part of the regular quota. If it is an advanced, if you check the box for the advanced degree quota, they take all of those cases. And let's say out of the 200,000, let's say that 70,000 were advanced degree cases. They take all those, 70,000, and then they count out 20,000 of the advanced degrees, because that's the advanced degree quota. Then they take all remaining 50,000 of the advanced degrees and they put them back into the pile. They mix them all up with all the degrees, and then they count out 65,000 for the regular quota. So if you have an advanced degree, you get 2 bites of the apple. But once the government counts out the 20,000 advanced degree, and they count the 65,000 for the regular quota, that's 85,000. That's the end of the H-1B quota, and it will be filled by April 1. In other words, that lottery process, you do the pre-registration, March 1 to March 20, anytime within that. It doesn't matter whether you get it in first. It's totally random. You file anytime between March 1 and March 20. Starting March 20, they will do the random lottery where they select 20,000 the advanced degree, and then they select 65,000 of the regular quota. This year, they completed that lottery process by April 1. If your case was selected, your pre-registration was selected, you are notified by the Immigration Service. That allows you 90 days to file your H-1B petition. So the pre-registration process, March 1 to March 20. Then they do the lottery where they select 20,000 advanced degree and the 65,000 regular. That's done by April 1. You're notified. Once you're notified to file your petition, the employer then has 90 days to file. So you have from April 1 until June 30 to file your H-1B petition. Now, here is a very important new development with regard to the pre-registration process, and that is previously, in years past, when you filed your petition, you had to have the degree that you were relying on at the time you filed. So if you wanted to be in the advanced degree quota, you had to have your advanced degree at the time you filed your petition. If you wanted to be in the regular quota and you were in a bachelor's degree program, but you had not yet completed it, you couldn't file because you didn't have your degree at the time you were ready to file. This pre-registration process is different. You do not have to have the degree at the time you file the pre-registration, as long as you will have the degree by the time you file your H-1B petition. So let's look at what that means. The pre-registration period is March 1 to March 20. Let's say you're a spring grad. Most people are going to graduate sometime in May, let's say May 10. So you do not have to have your degree. So let's say you're graduating with an advanced degree. You won't have that advanced degree when you file the pre-registration because you won't graduate till May. If you're in an undergrad program, you won't have your bachelor's degree at the time you file the pre-registration because you're not going to graduate until May. But under the current rule, you do not have to have that degree at the time you file the pre-registration. So you can file the pre-registration saying, I'm going to get my advanced degree by the time I file my H-1B petition, or I'm going to get my bachelor's degree by the time I file my H-1B petition. So you file the pre-registration. If your case is selected on April 1, you're notified that you can file your H-1B petition, but you can't file it until you have your degree. But you have 90 days to file that H-1B petition. So you can wait until graduation, you get your degree, then you file the H-1B petition. The Immigration Service will process that application, they will approve it, and it will be effective on October 1. So even if you have an employer willing to sponsor you for H-1B before you finish your program, the employer files the H-1B pre-registration. If your case is selected, you can file the H-1B petition starting April 1. If the H-1B is filed and then approved, it will be effective as of October 1. It cannot be effective earlier because that's when the quota is released. How can you work between graduation and October 1? OPT. You have to get your OPT, even if you have an employer willing to sponsor you for an H-1B as soon as you graduate. You still have to have OPT to bridge you until October 1. Now, in real life, there aren't very many companies who are willing to sponsor people before they graduate. There certainly are some, but in most circumstances, students will graduate in May, they'll have their optional practical training work card, and they'll go to work for an employer. They don't have an H-1B pending because they didn't have a pre-registration because they didn't have an employer to file one. So you graduate here, you go to work using your OPT, you get up here to October 1 when the quota is released. You don't care because you didn't have an application filed. What you're going to be looking at is March 1 of the year following your graduation. That is when you are going to want to talk to the employer about submitting a pre-registration on your behalf. Between March 1 and March 20, you file the pre-registration. On March 20, they start the lottery process, and as of April 1, you'll be notified whether your case was approved. If your case was selected in the lottery, you file the H-1B application. H-1B application will be processed, and it will be approved and effective as of October 1. But your OPT started in May after graduation. It'll go for 12 months, and it will end right here. What do you do between the end of your OPT and October 1 when the quota is actually released and your H-1B is effective? Well, it used to be that you had to leave the United States, but the government woke up one day and took a happy pill or something and decided that it was a stupid rule to require international students to depart during that gap in their employment. It's called the cap gap. It's a gap in your employment caused by the H-1B cap. So they came up with what they call cap gap relief. What that means is that as long as you file an H-1B petition, and that H-1B petition is filed with the Immigration Service before your OPT expires, then your OPT will automatically extend up until October 1 when the quota is released. So you will have uninterrupted work authorization this entire time. So that's how the H-1B lottery process works. You have the pre-registration, then they do the lottery where they select the 20,000 advanced degree, the 65,000 regular. You file the H-1B application, and assuming it's approved, that it's effective as of October 1. Well, let's say you're not selected in the lottery, and most people will not be selected. Or let's say your employer decides they're not going to sponsor you for H-1B. Do you have options other than the regular H-1B? And the answer is yes. There are certain organizations that are totally exempt from this lottery process. They're exempt from the quota altogether. These organizations can file an H-1B anytime. A university, you go to work for a university in an H-1B level position, that the university can file an H-1B anytime. The quota is irrelevant to a university. Even though private employers right now could not file an H-1B, Jeremy and his team could file an H-1B tomorrow if they wanted, and they probably will as soon as the new wages are released. Another exempt organization, nonprofits that are affiliated with universities, like a university-affiliated research facility or a university-affiliated hospital. Those organizations can sponsor an H-1B anytime they want. Certain nonprofit research organizations are exempt from the quota. Not all nonprofits are exempt from the quota. Only nonprofits that are engaged primarily in basic or applied research are exempt from the H-1B quota. And then finally, certain governmental research organizations like the Jefferson National Lab down in Newport News or the Los Alamos lab out there in Albuquerque. These government research organizations are also exempt from the quota, but that's it. Those are the organizations that are exempt from the quota. Every other organization in the United States, for profit or not for profit, is subject to this H-1B quota. Well, let's say you're working for an employer and you didn't get selected in the lottery. You're not working for a university so that you can't take advantage of the exemption from the quota. What other alternatives do you have? Are there any other temporary visa options other than this quota-based H-1B that you can take advantage of? And the answer is there are very limited options. First, if you are from one of these 5 countries, Canada, Mexico, Chile, Singapore, Australia, there are excellent options for work visas that are similar to the H-1B. Some of them have quotas, but the quotas are never exhausted. So you have the TN for Canada, Mexico. You have the H1B1 for Chile, Singapore. You have E3 for Australia. Very similar to the H1B in their requirements. If you have questions, if you're from one of these countries and you have questions about these options, feel free to send me an email or give me a call. I'm happy to answer your questions. Assuming you're not from one of these magical 5 countries that has these great options, L1 is certainly an option, but it requires first that you must be working for a multinational company, that is, companies that have operations outside the United States and operations inside the United States. And you have to have worked for that company for at least 1 year outside the United States if you are working in a specialized knowledge position or as a manager or executive. After working outside the U.S. for a year, you may qualify to return to the United States using an L1 visa. My office processes many Ls for multinational companies, and again, I'm happy to answer your questions. But assuming you're not working for a multinational, there is an option called an E-visa. E-visas are for individuals of countries that have treaties of trade and commerce with the United States. China is not one of those countries. India is not one of those countries. So E-visa is not available for citizens of China or India. You can see whether or not your home country is on the E-visa list by Googling E-visa treaty countries. You can see the countries that are eligible for E-visas. If your country is an E-visa treaty country, then you could get an E-visa to work in the United States for a company that is owned by citizens of your country. So, for example, let's say you're a French citizen. You could go to work for a company in the United States that is owned by citizens of France, and you may qualify for an E-visa. E-visa is also a good visa for entrepreneurs from treaty countries because it will allow you to open your own company and sponsor yourself because you'll be working for a company owned by citizens of your country, you. So e-visa can be an excellent entrepreneurial option. Well, let's say you're not working for an exempt organization like a university or a nonprofit research organization. You're not from one of the magical 5 countries. You're not working for a multinational, and you're not from a treaty country. What options are available to you if you are not selected in the H-1B lottery? Well, for most people, you'll have to wait until the next year to apply for the lottery. If your OPT will bridge you to that, then stick on your OPT and continue to work and file the H-1B the next lottery session. If you're not, then the next option for many students is that they just re-enroll in another degree program, re-enroll in another graduate program or an advanced degree program that they haven't had before. There are some other options that are extremely limited, not even worth going into because almost no international student qualifies for them. So those are the various options that are available. None of this, unfortunately, is very good news, and this is the part of these programs that is always sort of depressing for me, because if you are selected in the H-1B lottery, that's great, and you can work in the United States for 6 years and then pursue a permanent resident green card. If you are not selected, your options are extremely limited. But the lesson that I would like you to take away is that as an international student, it is very important for you at every stage to plan ahead. You need to plan ahead in your last semester of your degree program to make sure you file for optional practical training within that 90-day window. Once you get your OPT, you need to plan ahead to make sure that you file the H-1B during the pre-registration period. If you get the H-1B while you're working using the H-1B, it's important to plan ahead to start that permanent resident green card process if it is your desire to stay longer in the United States. And with that, I'm going to turn it over to Kevin and Jeremy, and we can take questions.
Yeah, like just said, we will be opening up for questions. So feel free to pop your questions in the chat. If you want to unmute yourself and show yourself on camera, just please be advised that, again, we are recording this, so this will be public information. But feel free to pop in your questions for either Mark or Jeremy, or for career services, you have career services questions. Thanks again, Mark, for that presentation.
Okay, looks like we got a couple of OPT questions right off the bat here. I can answer those quickly. If it depends on your start date. So Haley, it depends on your start date when you set it. So it's got to be within 60 days of graduation. So if you start OPT on June 1st, then it's gonna expire on May 31st of the following year, for example. Okay, and Zenat. So Zenat, when is OPT application finishing PhD? I mean, the OPT application is based on your graduation date. Doesn't matter if it's STEM or not. I mean, the STEM will come later, but PhD students, you have some options because you may graduate on the semester time, or you may also finish at different times of the year. And I would encourage you to talk to your assigned ISSS advisor about that timing. So, and let's see. CPT was not covered. This is not a CPT workshop. So that's an easy one. So yeah, Haley, the timeline is set. You can apply 90 days before graduation for a start date that is 60 days after graduation. So that's enough time. Basically, you're going to apply in early March for a start date, say in June or July or late February.
And when Jeremy talks about the start date, what he means is the actual effective date of the card. That's
Yes.
when you would be able to go to work for an employer.
Right.
It may be that you don't yet have an employer even as of the effective date. That's perfectly fine. Once that card is effective, which, as Jeremy said, you can make it effective anytime within that 60 days after graduation. Once the card is effective, you only have 90 days of unemployment time. So if you haven't found a job as of the effective date, you better start hustling to try to find employment, because you will only have 90 days of unemployment time. And if you have not reported that you found employment within that 90 days, then your record will be terminated in SEVIS.
Yeah, and I would encourage all of you, we will have multiple OPT workshops starting in January. So probably January, February, March, April, we will have OPT workshops to explain the OPT process to you. But you can also read all about it on the ISSS website. We have videos and etc. Information there that will teach you more about OPT. I really don't want to give an OPT workshop here, but I can answer specific questions. So there's a question here from Eunice about, I pursued a bachelor's degree in STEM. And I'm pursuing, yeah, the STEM degree outside of the US does not count for STEM OPT. It has to be a US degree in order to count for STEM. Yeah, Arun, you're asking that O1 question. Yeah, I would say go ahead. That's up to your employer to work on that O1 visa for you.
If you're interested in an O1, I process countless O1s. I would suggest my email information is on the screen. Send me a copy of your CV, and I can give you a very good assessment of whether I think you're going to qualify for O1. O1 is for individuals with extraordinary or outstanding abilities. So we're going to be looking for publications, presentations, prizes or awards, that sort of thing. But I do many O1s, so feel free to shoot me your CV.
Yeah. Raphael asked about if I don't get selected in the lottery, but I still have STEM extension, can I reapply on the fight? Yes, Raphael. That's the beauty of the STEM extension, because it gives you multiple shots at the H-1B process, multiple years. So Cindy is asking a specific question about Wharton and the OPT STEM extension. Cindy, the regular Wharton concentration, this is very specific to Wharton undergrads. The regular Wharton degree in economics is not considered STEM, but Wharton has, I think, 4 or 5 specific concentrations in Wharton undergrad that are STEM. So you need to talk to Wharton undergrad advising, to May Long, the advisor, if you want, or your assigned advisor at Wharton undergrad, to make sure that you are in one of those STEM degrees at Penn. That's very specific to Wharton. So you need to talk to Wharton undergrad advising about that. Wow, Eunice, Mark, what do you think of this one? TPS status. This is, wow, we tend not to advise on this at all, but Mark can.
Yeah, for TPS, we actually have an attorney in the office who is a specialist in these kinds of issues. If you could send me an email with your question, I'll be happy to pass that along. And her name is Crystal Malik. She would be happy to advise.
Yeah, and Eunice, we will, our answer on the OPT would be, you know, we will certainly recommend the OPT for you. That's your choice to apply for it. But we would advise you to consult with an attorney, such as Mark, to make sure that the OPT does not conflict with the TPS status. And that's up to you. But we would not stop you from applying for OPT. That's your choice. Anushrut's asking about home country defined by country of birth or by nationality, citizenship. I would say passport for our purposes.
If you're talking about for e-visa or for the TN, H-1B1 or E3, it is a country of citizenship. So you may have multiple citizenships.
Yeah, because we have students, especially for example, the TN visa from Canada.
Mhm.
You have folks who were maybe they were born in, I don't know, they were born in the UK,
Right.
but they're a citizen of Canada.
Correct.
And they have a Canadian passport. Then they can get a TN visa.
So
I've seen that many times.
For green card quota, it is country of birth. For all temporary visa options, it is country of citizenship.
Cindy, you're asking a basic OPT question. Yeah, that's basic. Regular OPT is 1 year. Okay, everybody gets 12 months of regular OPT, and then the STEM extension is for 2 more years after the initial first year.
Any other questions from students that you may have? Again, Mark provided his email address. If you have questions, you can also schedule an appointment with ISSS. But
And I'd like to encourage everybody on the OPT front. We will open up the OPT e-forms in IPEN. I think, I'm not exactly sure on the day, but I believe it is February 18th of 2021. Okay, that's the date that we're going to open it up. That's the 90 days before graduation for spring 2021. So ISSS is ready for the, OPT season. Will kick off on, February 17th, 18th. So be ready for those dates. Another plug I want to put in here about OPT for any of you who are seniors or master's students, anybody graduating in this, May of 2021. A big thing about OPT is you must be physically in the United States to apply for OPT. Okay, and I know many of you are out of the US and you've been studying remotely and things like this. To apply for OPT, you've got to be in the US in F1 status. So please take that into account for your travel plans in the next 3 or 4 months. Okay, that's a concern of ISSS, honestly, is that a lot of our students are scattered around the world due to the virus, and you can still attend class remotely and you can still graduate, but to apply for OPT, you've got to be in the US in F status to be able to do that. So keep that in mind, and please tell your friends to make sure that they find their way back here in the spring, in February or March, January, February, March, April. You need to be back in the US. So you don't have to be in Philadelphia, but you need to be in the US. So.
all right. Well,
I certainly miss Philadelphia, and as I look at my clock, I'm running out of time. So
yeah.
Thank you all very much for your attention, and I will send Kevin a copy of the easy guide to hiring foreign graduates that I mentioned, and feel free to distribute that to anybody who attended.
Great. Thank you so much, Mark, for your time. We really appreciate it. Thank you, Jeremy, for your input as well. And thank you, everyone, for attending today.
All right. Thanks, everybody.
Thank you all.
Stay safe.
Thank you, Mark.
Bye-bye.